Hello, my name is Mark Satawa, Principal Attorney at Satawa Law. Welcome to today's video blog. The topic for today is Title IX and the dangerous path we're going down in student disciplinary hearings. Now look, student disciplinary hearings are not new. They've been going on for a long time. However, in the wake of #MeToo, Larry Nassar, the wrestling coach at Ohio State, etc., the attack on the protections afforded students in these Title IX hearings is really, really dangerous and getting to a critical point. Traditionally, the United States Supreme Court and the Supreme Court in Michigan have ruled that you have a property right in your education, and that property right cannot be infringed or taken away without due process. For that reason, these disciplinary hearings had rules. And to be clear, what we're typically talking about is a date rape or campus sexual assault where one student accuses another student of being sexually assaulted on campus. Traditionally, you had certain protections. However, universities throughout the country, and certainly in the state of Michigan, are almost competing with each other to see how quickly and how far they can go in taking those protections and away from students accused in these hearings. In a 2018 case out of the University of Michigan, the Federal Sixth Circuit Court of Appeals ruled that the University of Michigan's disciplinary hearings violated the Due Process Clause. What kind of rights are we talking about? We're talking about the right to be assisted by counsel, by an attorney, the right to confront and question your accuser, the right to be present at the same hearing as your accuser so that you or your lawyer can question that person, the right to appeal a decision, whether or not you have the right to be tried by a panel of students, or whether one or two or three school administrators can make this decision. The main problem with the University of Michigan's student disciplinary process was that it did not allow the accused student to confront and question the accusing student at the same hearing. That policy said that the accusing student could come to the hearing. They would be questioned by the people running the hearing. She would leave or he would leave. The accused student would come. The panel would question the student accused of sexual assault. They would ask the questions, that person would leave, and they would render a decision. No, says the Sixth Circuit, that policy is unconstitutional because it does not allow the accused student to question and confront at the same hearing live the person accusing them of sexual assault. This is going to continue to be developing, and it will develop every day, because just when one policy gets overturned by the Sixth Circuit, another school is going to pass another. So, for example, in 2019, Michigan State did several things that sort of, edged them ahead of the University in Michigan on trampling the rights of those accused of campus sexual assault or date rape. Michigan State instituted a policy that if you get accused of sexually assaulting a student on campus, that you can be suspended, you can be kicked off campus, suspended from university campus housing until the matter is resolved. A federal district court judge reviewing that policy said the policy was okay and was not unconstitutional. I would expect an appeal of that decision in light of the University of Michigan case from the Sixth Circuit the previous year. In 2018, I would expect an appeal of that decision from Michigan State to the Sixth Circuit as well. Michigan State having its own problems in the removal of John Engler, initially appointed a former Court of Appeals judge, Talbot, to head their Title IX compliance and hearings, administrative hearings office, a person who has extremely close ties to John Engler, That got Michigan State a lot of negative publicity. Judge Talbot quickly left that role and was replaced by an individual who went on record as saying that new director of Title IX compliance and hearings at Michigan State, Rob Kent, announced sweeping changes to the way Michigan State was going to conduct these hearings. These hearings were now going to be done electronically. So the student accusing and the accused student would appear via webcam or Skype or Zoom, and the meeting would be conducted in that fashion. In fact, he has a quote. The quote was, "No one is actually going to have to confront the person through cross-examination." Well, that's interesting because the Sixth Circuit in 2018 said that's exactly what is required, that the accused student has the right to confront and question the student making the accusation against them under the Due Process Clause. Folks, it's a mess, all right? It's quite simple, plain and simple. Title IX hearings right now are a mess, and there is no clear answer. It is not black and white. These cases exist in the gray. If facing a Title IX campus disciplinary hearing, first of all, you need a lawyer. Even if your school tells you you don't get the right to the assistance of an attorney can still consult you and can still help you prepare for that hearing. And even if the lawyer is not allowed to speak for you during the hearing, most schools will allow the lawyer to sit with you at table and to help you conduct the hearing yourself. In doing that, you need to start with your own school's own student handbook and own student code of conduct. I mean, the rules upon which the school says they themselves are going to follow in these hearings. And you got to make sure your school follows its own published guidelines and rules. If those rules deny you any of these basic due process rights, the right to assistance of counsel, the right to confront the accuser, the right to question the accuser at a live hearing, the right to a jury of your peers, in other words, a determination made by other students, not just a school administrator, the right to appeal that decision, the right to stay in school while the process is going through, in violation of Michigan State's announced policy that they can suspend you during the pendency of this hearing. If any of those things exist, you need to hire an attorney, and that attorney needs to go to federal court. It needs to file a lawsuit, get an injunction, and prevent the school from trampling on your rights like that. You need to file an objection to those procedures with the school to make sure that you preserve any and all administrative remedies in the school's hearing itself. And most of all, you need to believe in yourself. You need to know that this is a false allegation. You need to know you didn't do this. You need to go to the other witnesses that were there, and you need to be prepared to fight tooth and nail to protect your future. Because quite frankly, that's why you're there. You're at this school, you're at this college or university trying to make sure and plan your future out. That college degree is going to be the key to you getting a job, to moving forward, to going on to a career. And that can all be threatened. That can all be threatened by these Title IX disciplinary hearings. Don't let it happen to you. There are ways to fight, and there are ways to fight back. And as I said, it starts with getting a copy of your own school's rules and hiring a good lawyer, a lawyer who knows these cases, has done these cases, and successfully navigated, litigated, and won these cases. We at Satawa Law have a lot of experience with sex crimes and Title IX work. We're happy to help you. You can call us anytime for a confidential, no-cost consultation and meeting. That's today's vlog. I hope you enjoyed it. I hope it was informative. Mark Satawa, principal attorney at Satawa Law. And as always, we at Satawa Law are defending your rights and protecting your future.